A pleasant afternoon to everyone who is joining us today here in the Philippines, and a pleasant morning to our distinguished author who is in Europe. Welcome to the Colloquium on Philippine Materials and International Law, a book written by Judge Raul C. Pangalangan, Professor of Law and former Law Dean of the University of the Philippines, and former Judge of the International Criminal Court at The Hague in the Netherlands. This event is organized by the UP Law Center Institute of International Legal Studies and co-presented by the UP College of Law and the Philippine Society of International Law. Before we begin, I would like to go through some housekeeping matters. In case of technical difficulties, please try closing all bandwidth-consuming applications or browsers. We would like to request that you keep your microphones on mute to avoid background noise. Throughout this afternoon's colloquium, we invite you to contribute in the discussion by posting your questions for our distinguished author and the panelists on our Q&A or the chat box. I now invite the Dean of the UP College of Law, Dean Edgardo Carlo L. Bistan II, for his opening remarks.
Thank you, Paula. Judge Raul Pangalangan, it's good to see you. Ma'am Beth Agiling Pangalangan, of course, is a colleague in the faculty, but for this occasion is also representing the Philippine Society of International Law. Members of the faculty, colleagues in the faculty of the UP College of Law, and our guests from the Philippine Society of International Law, students, and our other guests. Pleasant afternoon to you all. There have been at least 2 events that I know of prior to this colloquium that have been held to herald and celebrate our very own Judge Raul Pangalangan's latest book, Philippine Materials in International Law. The UP College of Law co-organized one of those events with UP Visayas as part of the commemoration of the latter's 75th year in Iloilo, and I was a commentator in that event. Even while this last event with UP Visayas was in the drawing board, preparations for this present colloquium were already underway. It must be highlighted at the outset that each of these events can and has something unique to offer because as a curation of materials on various aspects of international law, Judge Pangalangan's book presents many openings or lines for commentary and inquiry. The present colloquium, for one, takes on a greater number of these openings. While our event with UP Visayas primarily touched on the first two chapters of Judge Pangalangan's new book, with chapter titles Constituting the Philippine State in International Law and the Armed Conflict with the United States Before the Courts and Courts Martial, this colloquium will be a forum for discussing 4 other chapters on sources of international law, Philippine territory, human rights cases from the Marcos dictatorship, and international criminal law. More importantly, for me at least, our discussants commentators for this colloquium are all members of the UP College of Law faculty. I thank the Institute of International Legal Studies and the Philippine Society of International Law for accommodating this aspect of the colloquium that I requested. The idea is born of the belief that the intellectual activism and vibrancy of any faculty is best demonstrated or witnessed when its members interact with each other to discuss, critique, and offer alternatives to the ideas and perspectives of their colleagues. Our faculty is very much capable of this, but we tend to do our own thing because of the demands of our work. We rarely have time to be each other's sounding board or devil's advocate. I believe we can only grow and improve more as individual thinkers and as a community of scholars with more exchanges such as the present colloquium. We will therefore work to have more exchanges like this, broadcasted or otherwise. I also made this request because I believe that our dear Judge Raul Pangalangan, a colleague and professor to our panelists and perhaps many also in the audience, deserves nothing less than the best inputs and challenges from his colleagues here in the UP College of Law. This exchange is not simply about commending or celebrating a colleague's work. It is when we see and communicate gaps or rooms for improvement when we really contribute to each other's scholarship. To paraphrase an adage about friendships, it is in criticizing the work of a colleague when we show that we really care. So beyond our felicitations, I hope we can also honor Judge Raul with pointed but constructive commentary. I know from the previous commentary I shared on 2 of the chapters of Judge Pangalangan's book that he is very much receptive, or at least tolerant, of alternative views and suggestions on improving the context he employs to introduce his collection of materials. With the great breadth of the subject that Judge Raul attempts to cover in his book, and if I may hazard a guess, with a subsequent edition likely being planned because of the very nature of Judge Raul's approach, I am certain that our man of the hour will appreciate further inputs and suggestions from his colleagues in the UP Law faculty. In closing, let me thank our panelists from the faculty, Professors Dante Gatmaytan, J. Batongbacal, Rommel Casis, Raj Palacios, and Mike Chu, for taking the time to contribute to this discussion of Judge Pangalangan's latest work. Thank you also to the Institute of International Legal Studies of the UP Law Center for taking on the lead role in the staging of this colloquium. The college's deepest gratitude must also be extended to the Philippine Society of International Law for co-organizing this colloquium with the college, as well as for being a constant and reliable partner in many of our other international law projects. To Judge Raul Pangalangan, congratulations once again on the publication of your most recent work, and thank you for giving us the honor and privilege of featuring it in this colloquium. We hope you appreciate and enjoy the next 2 hours. Finally, to our audience, thank you for joining us, and we hope you enjoy what we and our speakers have prepared for you. We will be working hard so that this will not be the last time that you will be able to witness an exchange of this sort among our faculty. Again, thank you very much, and I wish you all a pleasant afternoon.
Thank you very much, Dean Vistan. We now invite the president of the Philippine Society of International Law and herself a professor of law at the UP College of Law, Professor Elizabeth H. Agiling Pangalangan, to give her message.
Good afternoon, everyone. It is my pleasure to welcome our panelists and guests to our colloquium on the book entitled Philippine Materials in International Law, an important work of scholarship by our honored speaker, Judge Raul Pangalangan. Together, the UP Institute of International Legal Studies, the UP College of Law, and the Philippine Society of International Law have organized today's event to engage in academic discussion with the author himself and explore different perspectives from other scholars. The recent years have brought matters of international law closer to home, creating more frequent conversations amongst both legal experts and the general public. Notable issues such as the West Philippine Sea Arbitral Award, the International Criminal Court probe on the Philippine drug war, and the foreign litigation of human rights victims against the Marcos dictatorship are among many that continue to highlight the Philippine voice in international law. However, as noted by Judge Pangalangan in his book, academic discourse has traditionally found its canons in Western sources and reinforced the idea of international law as alien or colonial among Filipinos. This book, curating primary sources rooted in Philippine experience, is thus a valuable contribution to scholars and practitioners worldwide, ensuring the development of international law that fits the context and reflects the vantage point of the Philippines. Philippine Materials in International Law is particularly significant for professional academic societies, such as the Philippine Society of International Law. The PSIL plays an important role in providing expertise on international law matters affecting the Philippines, such as the utilization of the oceans surrounding our territory, the regulation and protection of foreign-owned property and investments, or issues such as the Ukraine-Russian conflict and its domestic impact. With the PSIL's overarching goal of promoting broader understanding of this field in the Philippines, this book will be instrumental in providing perspectives that resonate with shared national experiences. The book's comprehensive discussions on the historical use of international law by Filipino judges and lawyers in domestic courts and international tribunals will also serve as a cohesive reference for scholarly work or policy advice to government institutions. This book also serves as a significant contribution to the field of international human rights law, which has been characterized as distinct from other self-contained regimes in the past, but is increasingly being recognized as integral to all areas of international law. The book's emphasis on the process and enforcement of foreign decisions against human rights violations in the Philippines underscores the need for universal efforts to ensure the protection of human rights, which will be discussed further by one of our panelists. We are thus grateful for the presence of our esteemed author and speaker, Judge Raul Pangalangan, who will be presenting a more in-depth discussion on the key points in his book. We are also thankful for the presence of our panelists, Professor Rommel Casis and Professor Palacios, who will be discussing the chapters and sources of international law, Professor J. Batongbacal, who will be commenting on the chapter on Philippine territory, Professor Dante Gatmaytan, who will give remarks on Judge Pangalangan's chapter on human rights cases from the Marcos dictatorship, and last but not least, Professor Tiu Jr, who will be sharing with us his reactions to the chapter on International Criminal Court. Again, welcome to all our attendees, and I look forward to an engaged and engaging discussion today. Thank you very much.
Thank you, Professor Beth. It is my distinct honor to introduce Judge Raul C. Pangalangan, a former judge at the International Criminal Court of The Hague. He has resumed this post as Professor of Law at the University of the Philippines, where he also served as Law Dean. He has taught international law at Harvard Law School as visiting professor and has served as Director of Studies and later lecturer at the Hague Academy of International Law. He has also held visiting appointments at the Hong Kong and Melbourne universities and has lectured at the Salzburg Seminar on International Criminal Law, Humanitarian Law, and Human Rights, and as keynote at the Irish Center for Human Rights, Thessaloniki Institute of International Public Law, and Waseda University in Japan. He's currently a member of the Permanent Court of Arbitration at The Hague and a judge of the Asian Development Bank Administrative Tribunal in Manila. He sits in the Governing Council of the Asian Society of International Law. He received his AB cum laude and LLB from the University of the Philippines and his LLM and SJD from Harvard Law School. He's the only Filipino who holds diploma from the Hague Academy of International Law. We welcome our distinguished author, Judge Raul C. Pangalangan, who will give his presentation on his book, Truly a Valuable Contribution to Legal Scholarship, entitled Philippine Materials and International Law.
Thank you so much, Paula, for the very kind introduction and also for the generous introduction. Dean Vistan, Professor Elizabeth Aguiling Pangalangan, my president of the Philippine Society of International Law. I thank both of you for framing our discussion this morning. You both represent the institutions and the communities which are most relevant for the kind of discussion that, as described by Dean Vistan, that we hope for. And that is a colloquium among fellow scholars, thinkers in this field, and to engage with the issues that were dealt with in the book. Professor Tiu advised me earlier that I should make this brief presentation and then to pick it up later in the Q&A. I thank Mike and his team for actually identifying the four of the chapters which I think are the most relevant for our discussion today. The longest chapter, of course, is on sources of international law, and I'm so glad that Professor Rommel Casis and Professor Raj Palacios have taken on the challenge of dealing with one of the most difficult areas for Filipinos in dealing with international law. It's volatile. There are so many subtle changes in the treatment of doctrines, and over the years that those positions have actually evolved and changed. I am so glad that Jay Batongbacal is on board to discuss one of the biggest international law issues that we face today in the Philippines, and the one issue for which today the Philippines is at the forefront in public international law, and that is our claims in the South China Sea as against China. I'm also glad that Mike will be dealing with the issues in international criminal law, which is at the heart of both political debates in the Philippines, of course, the basis of several Supreme Court decisions, and also potentially an ICC investigation that will yield doctrinal innovations for the field. And I left my favorite topic for last, the Marcos issues as regards human rights and hidden wealth. I'm so glad that Dan, with his own personal record as an activist, has taken on this topic. When I chose this format, this presentation of curated original primary materials in international law, it is this chapter which actually pushed me to do it. You see, I felt that it is important at this stage in our history that we teach the international law material relating to the Philippines using the original records, because I feel that this is a season of fake news, and readers, students, the profession, we would like to judge for ourselves. And we have encountered many of these issues, usually in journalistic material. In other words, versions of other people about what happened. And I sense that there was some resistance. There was some doubt about the credibility of some of these accounts. Also, it is often, I mean, dealing with issues outside of Marcos, when we deal with, for instance, as Dean Vistan mentioned, the material from the Philippine Revolution and our war against the United States. While we know that there were proceedings, court-martial proceedings, Supreme Court cases on that period, we rarely encounter these materials in the original. And I felt that for our historical moment, it is the original material which will convince people best about what happened. And that is why I feel it is most important, especially for the Marcos human rights abuses during the dictatorship. For instance, I myself, when I encountered the US Supreme Court decision on one of the hidden wealth cases, it struck me reading that decision that Marcos created a shell corporation in Panama in September 1972, the very time he declared martial law. And I wondered if he said that the country was under siege at that time by the communists in order to justify Proclamation 1081. I was surprised he actually had the time to create the shell corporation out there, and why he was doing it at that moment when he seized the complete power in our country. So just by way of closing this introduction, I would like to look at the book both from the pedagogical reasons that I wrote it as a Filipino professor of international law, but also for its historical purposes as a Filipino who confronts the challenges faced by our country today, in the hope that the book can enlighten, that can contribute something to illuminating that debate, drawing out the main issues, and bringing that debate on firm legal and factual footing for our people to decide our future together. Thank you very much.
Thank you very much, and congratulations again, Judge Raul C. Pangalangan. We're certain that our audience is really looking forward to securing a copy of your new book, hearing your thoughts on the presentation of our panelists later, and having their questions answered in our Q&A segment. We now move on to the panel discussions, where our esteemed faculty of the UP College of Law will present their insights and reflections on key chapters of Judge Raul C. Pangalangan's book in relation to their areas of expertise. It is my honor to introduce our first panelist, who will be providing his analyses on the chapter on sources of international law. Professor Casis teaches international environmental law and policy in the LLM program of the University of the Philippines and public international law in the JD program. He also teaches obligations and contracts, torts and damages, and supervised legal research. Professor Casis received his LLM from Columbia University in 2010, specializing in international law, climate change law, and environmental law. He earned the distinction of being a Harlan Fiske Stone Scholar, which is a magna cum laude equivalent. In addition to teaching full-time, Professor Casis is the director of the Institute of International Legal Studies of the University of the Philippines Law Center. As director of ILS, he's involved in and supervises various research projects involving international law, including but not limited to international criminal law, international environmental law, international humanitarian law, and most recently, space law. Professor Casis also serves as faculty advisor to the moot court teams of the College of Law, including the Jessup, Stetson, Asia Cup, IHL, Prize, and Jackson moot court teams. As the advisor, he has steered a number of these teams to championships both locally and internationally. We now welcome Professor Rommel Casis.
Thank you, Paula, for that very generous introduction. Please allow me to share my screen for the presentation. So, good afternoon, Judge RCP, Professor Beth, Dean Vistan, colleagues in the faculty. It is an honor to talk about a work of such importance as this. And it's also a privilege to be part of such a distinguished panel, two of whom are my former professors, Dr. Batongbacal and Professor Gatmaytan. On the other hand, Professor Palacios was my contemporary in the law school. I believe he was only 2 years ahead of me, while Professor Mike Chu was one of my students. My role in this panel is to talk about Chapter 5 on sources of international law. Since we are only given 12 to 15 minutes to discuss today, I thought it best to limit myself to the 3 questions that we were given by the organizers. First, where and how does the specific book chapter figure in your particular field of expertise? Second, how does the substance of the chapter contribute to the field, and in what way does it move the field forward? Third, in addition to the impact of the Philippine materials discussed in the book on the international legal landscape, how do these materials deepen or broaden our understanding of Philippine domestic legal areas? So let me begin with the first question. Where and how does a specific book chapter figure in your field of expertise? Now, I must admit that sources of international law is my favorite subject in international law. And if you'd indulge me, I'd like to just go over some of the materials that I've written on the matter. Firstly, in 2017, I wrote a paper titled Developing Country Implementation of Multilateral Environmental Agreements, the Philippine Experience. This paper discusses how the Philippines chooses to implement its international environmental obligations. And interestingly, what I found was we do not enact legislation for these treaties, but we choose to apply them using administrative issuances. Also that same year, in the Philippine Yearbook of International Law, I also published a paper titled A Brief Review of the Precautionary Principle as Observed from the Philippine State Practice. Now, after discussing the history, the content of the current or the binding effect of the precautionary principle, this paper describes how it is used under Philippine law and jurisprudence. In 2018, I wrote a paper titled Dualism and Incongruence Between Objective International Law and Philippine Practice of International Law. And this paper was written in honor of our dearly departed former Dean Merlin Magallona. And this paper discusses the monist versus dualist debate, one of Dean Magallona's favorite subjects. And using Philippine case law, it discusses the conflicts between what Dean Magallona calls the objective international law and the Philippine practice of international law, and the challenges that these conflicts create. In 2019, I published a paper titled Recustomizing Customary International Law. And in this paper discusses the ILC, International Law Commission draft conclusions on the identification of customary international law and the problems with the customary 2-element approach and possible alternatives to this traditional approach. Also in 2019, I had the privilege of working with Ambassador J. Eduardo Malaya, and we had a book published titled Treaties, Guidance on Practices and Procedures. Now, this book is intended to explain in the simplest terms the law and treaties from the international and domestic points of view. In 2020, I published a paper titled Domesticating International Law, Resolving the Uncertainty and Incongruence. Now, this paper analyzes the main issues that arises from domestication of international law in the Philippine legal system and proposes solutions. Also, in 2021, I had the privilege of being an editor and contributor to the Encyclopedia of Public International Law, and my contributions to this volume, most of them, were centered on sources on international law. Now, the reason why I'm sharing these materials with you is that I want it to be clear that my current research and my passion at the moment with respect to international law is centered and revolving around sources of law. And it was a joy reading the chapter on sources of international law. And I can't wait to share some of the insights with you today. With respect to the second question, how does the substance of the chapter contribute to the field? And in what way does it move the field forward? Well, in my opinion, I think the volume contributes in at least three ways. First, it provides a summary of the current state of law and jurisprudence. Second, it sets a framework of analysis. And third, it identifies the questions and issues of concern. Now, with respect to the first contribution, the summary of the current state of law and jurisprudence. In the overview alone, the chapter outlines the four key constitutional provisions on international law, and Judge RCP identifies two of these, the treaty-making clause and the incorporation clause, as the most important, and I agree. The two other provisions, of course, are the military basis clause and the judicial review clause. The chapter also discusses key international law issues, including executive agreements, soft law, recommendations of human rights bodies, and termination and withdrawal from the treaty. Now, apart from the overview, the materials themselves are a rich resource on many topics on international law. So let me just give you some examples. The materials gives us information on the binding effect of IHR instruments, the continuity of states, requirements for general principles of law, erga omnes obligations, jus cogens norms, the importance of municipal court decisions, unilateral declarations, ratification of treaties, pacta sunt servanda, and many others. So the curated materials do provide us with a lot of information on the current state of the law on these principles from the point of view of the Philippine Supreme Court. Also, the volume, or the chapter in particular, provides for a framework of analysis. And here, Judge RCP explains that the chapter 5 is about how the sources of international law identified in the ICJ statute are applied domestically. To do this, he sets out the two concepts that must be distinguished. The first concept is the question of whether a rule of international law is binding upon the Philippine state. Now, this has two aspects. The first is external, or vis-a-vis other states, or how an international obligation becomes binding upon the Philippines. The second aspect is internal, or vis-a-vis other citizens or persons within the jurisdiction, or how an international obligation is incorporated into national law and can be invoked by persons against the state. The second concept is the question of how international law rules become domestic law. Thus, what I found very interesting as he begins the chapter is that Judge RCP separates the issue of binding effect with the issue of domestication. Now, this is a very useful framework in analyzing international related questions. It tells us whether we should be relying on international law principles or domestic law principles in resolving the dispute. It depends which concept or which aspect we're trying to deal with. Now, the third contribution is about questions and issues. And as you could possibly tell from the topics of my past papers, there are many questions and there are many issues with respect to how the Supreme Court understands, interprets, and applies international law. To give a few examples, first is what I would like to call the overuse of the incorporation clause. Now, as Judge Pangalangan has pointed out, the incorporation clause has been validly applied to two non-treaty sources, custom and general principles of law. However, Judge RCP also notes that it has also been used to make ratified treaties binding domestically, and indeed make unratified treaties binding domestically qua international custom. Now, this is of course wrong, and the error is perhaps due to a misunderstanding. that the phrase generally accepted principles of international law found in the incorporation clause refers to all of international law. Of course, that cannot be the case because otherwise the treaty clause would have no meaning. The incorporation clause is not meant to be an open door where all manner of principles, both binding and non-binding, can find its way into the Philippine legal system. The second question or issue is external internal effects of the treaty-making clause. Earlier, we noted that Judge RCP separated the issue of binding effect of international law and domestication. With respect to the treaty-making clause, Judge RCP cites Dean Magallona, who states that this clause deals with both the external and internal aspects of the treaty. That is to say, that the treaty thus becomes binding internationally and effective domestically as national law. However, Judge RCP notes that some Supreme Court decisions suggest that it deals solely with the external binding aspect of the treaty. By that account, a treaty becomes binding internationally under the treaty-making clause, but it needs the incorporation clause to make it enforceable domestically. I think this illustrates a misunderstanding of the two concepts which Judge RCP introduced in this chapter. Specifically, that the question of binding effect is distinct from the question of domestication. However, the fact that these two issues are separate does not mean that the treaty clause only pertains to the first while the incorporation clause pertains to the second. In fact, what determines whether a valid treaty is binding domestically requires the application of international rules, for example, the rule on that particular treaty when it becomes in force, and the application of domestic rules, for example, whether a treaty is deemed to be self-executing or not. But never will a treaty require that the incorporation clause, a treaty will never require the incorporation clause in order to be enforceable. Another issue would be the enigma posed by executive agreements. Now, executive agreements are simply international agreements without Senate concurrence. Judge RCP notes that there is no textual basis for this, except that in the Constitution's section on the judiciary, we find the expression treaty, international, or executive agreement as matters subject of judicial review. Judge RCP notes that the executive agreements have of late been used to circumvent anti-corruption legislation, for example, when the government signs foreign loan agreements that require the Philippines to exempt the projects from the bidding requirements and procurement laws. So the issues pertaining to executive agreements deserves its own forum, and there's a lot to say about this topic. However, one thing is clear, in my opinion, the Philippine policy on this matter is not congruent with international law. Finally, with respect to the third question, how do the materials deepen or broaden our understanding of the Philippine domestic legal areas? I have 2 points. First, I believe it demonstrates the Supreme Court thinking, quote unquote, regarding international law principles. The chapter provides excerpts of Supreme Court decisions that discuss international law principles, and the amount and variety of examples provides a comprehensive survey of judicial tendencies when it comes to international law. The chapter therefore saves the professor and the student the trouble of wading through many cases, as the excerpts provide a more digestible format for understanding the issues. My second point, I believe that the volume transforms the reader into an exegete. Similar to what Dean Magallona did in his seminal work, The Supreme Court and International Law, Problems and Approaches in Philippine Practice, Judge RCP identifies the Philippine cases, which displays the Philippine court's understanding of international law. But one thing Judge RCP does differently, I think, which is an improvement from what Dean Magallona did, is that the former does not, Judge RCP does not push for his own interpretation of the text. He leaves it up to the reader to analyze it and interpret it. In other words, Judge RCP transforms the reader into an exegete, a person who is able to draw from the text significant meaning. Reading the book requires the application of what I like to call legal hermeneutics. Thus, it trains the reader to be an academic who can analyze text on their own and not be reliant on the interpretation of commentators. I think such method is conducive to training better professors and students. In conclusion, this chapter on sources of international law is my favorite chapter in the volume. And fortunately, this means that my students can expect more additions to their reading assignments. Thank you for your kind attention. That ends my presentation.
Thank you very much, Professor Casis. We are honored to have as our next panelist, Professor Raj Palacios. You'll also be presenting on the chapter on sources of international law. Prof. Andre Palacios, also known as Prof. Raj, teaches international law in the Juris Doctor and Master of Laws program of the University of the Philippines. As an international law specialist, Professor Palacios chairs the International Law and International Affairs Committee of the Integrated Bar of the Philippines. He's also the executive director of the ASEAN Law Institute. Before teaching, Professor Palacios served as a senior lawyer at the World Bank and assistant to the Philippine Permanent Representative to the World Trade Organization, where he assisted the Philippine government in its WTO dispute with the US and EU involving Philippine excise taxes on distilled spirits. He also served as Undersecretary and head of the Public-Private Partnership Center of the Philippines. He was also an assistant secretary in the Office of the President and the General Counsel of the Philippine government entity implementing an international infrastructure and development program. He now serves as a legal expert for infrastructure projects funded by the Asian Development Bank and continues to advise the Philippine government and private entities on infrastructure and PPP projects. We now welcome Professor Raj Palacios.
Good afternoon, Paula. Thank you for that introduction. I must apologize. I'm trying to turn on my camera, but I'm not able to. It says my video is not starting. So my apologies for that. I will keep on trying. Good afternoon, everyone, to our Dean Vistan, our colleagues in the faculty. Of course, a pleasant morning to our distinguished book author, Professor of Law and former International Court Judge, Dr. Raul Pangalangan. A pleasant morning as well to the President of the Philippine Society of International Law, Professor Elizabeth Agiling Pangalangan. I will keep on trying my camera. I'm honored to be part of this panel of UP Law faculty members who have been invited to share their insights on how this book by Judge Pangalangan is making an impact in our respective fields of study. We have on the panel experts in public international law, the law of the sea and territory, constitutional law and human rights, and also international criminal law. Judge Pangalangan's carefully curated collection of Philippine materials in international law is an important contribution to legal scholarship on the intersection of international law on one hand and Philippine law on the other hand. There is a lot of excellent scholarship on international law, also a lot of excellent scholarship on Philippine law, but there is a dearth of legal scholarship examining the intersection of the two systems. I sincerely thank Judge Pangalangan for devoting his precious time to make this important contribution to this vital but under-examined area of law. I'm still not able. Judge Pangalangan said that among his goals in making the book are, number one, to retell Philippine history using international law. And number two, to re-examine international law using the Philippine experience. I think the book has very much achieved these two goals. I understand that the book is a product of his long years of teaching and researching international law, almost 4 decades, if I'm not mistaken. Judge Pangalangan has been eloquently and very effectively retelling Philippine history and re-examining international law in his many law lectures through the years. I was a student I consider him my mentor, and I diligently attended his lectures at the UP College of Law in the 1990s and also at the Hague Academy of International Law and the Institute of International Public Law in Greece in the early 2000s. In his many lectures, Judge Pangalangan shared how the Philippines has enriched international law through the Yamashita Command Responsibility Doctrine, the Kuroda case, the Marcos cases, the military bases cases, even the Iloilo claims case, and many other Philippines-related cases. Judge Pangalangan's efforts to retell Philippine history and re-examine international law using the Philippine experience continued even while he was busy with his heavy caseload and punishing schedule at the International Criminal Court. He was in the City of International Law at The Hague for the last 6 years, but during his period away, Philippine law and its contribution to and application of international law was still on his mind, and I'm sure also in his heart as he prepared this book. The intersection of international law and Philippine law can be viewed from the perspective of practitioners of international law and also from the perspective of Philippine lawyers. The intersection of the two legal systems from the Philippine lawyers' perspective is my area of interest. We try to teach this to JD and LLM students at UP Law and to law students at Bicol University, where I have lectured as a resource person. Every semester, we hold a symposium where students present their hypothetical case studies on how international law can be applied in Philippine cases. We also try to teach this to practicing lawyers through the Integrated Bar of the Philippines and through the MCLE lectures that I give. We are happy that the Philippine Judicial Academy, through its International Law Department, is planning to teach it to Philippine judges, and that the Legal Education Board, through its LEAP program with UP, will teach it to international law lecturers in Philippine law schools. As someone interested in the intersection of international and Philippine law from the Philippine lawyer's perspective, my favorite part of Judge Pangalangan's book is his chapter on sources of international law. In this chapter, he explains and presents important legal materials on how rules of international law, coming from its three sources, are applied domestically in Philippine national law. I am very happy to note that Judge Pangalangan chose to include the important work of our beloved late UP Law Dean Merlin Magallona, another giant in the field of international law. By way of comment on this important chapter in Judge Pangalangan's book, I will touch on two things. First, on the state of this critical but under-examined area of law, and second, on what I see to be the valuable contribution of Judge Pangalangan's book to this area of law. On the first point, as previously noted, the intersection of the two legal systems is important from the perspective of international lawyers and of Philippine lawyers. From the Philippine lawyer's perspective, the intersection of the two legal systems determines how rules of international law are domesticated and become Philippine legal rules, and as such, become a source of Philippine rights and obligations that may be invoked before and enforced by Philippine courts, administrative tribunals, and executive agencies. For example, the Philippine law on the intersection of the two legal systems determines whether a Philippine court may convict an accused for war crimes, despite the absence of any Philippine statute criminalizing war crimes as such. It determines whether an international organization may be sued before a Philippine labor arbiter, despite possible violation of its employees' right to security of tenure. It determines whether an ambassador has immunity from Philippine suit, despite his possible breach of a contractual obligation. It also determines whether a presidential candidate is considered to be a natural-born Filipino on the basis of an international law presumption that her parents are Filipinos, notwithstanding the absence of any Philippine statute providing for such presumption. Despite the importance of the Philippine law on the intersection of the two legal systems, there is very little material explaining to judges, government lawyers, private practitioners, law professors, and law students how rules of international law are domesticated to become Philippine legal rules, and how they can be invoked before Philippine courts and executive agencies. There are the occasional Supreme Court decisions applying rules of international law in Philippine cases, but as Judge Pangalangan explains in his book, the Supreme Court's analysis of how rules of international law become Philippine rules has been oscillating, even arbitrary. On my second point, Judge Pangalangan's book is a valuable piece of legal scholarship on this critical but under-examined area of law. Through his book, Judge Pangalangan has achieved what many legal academics hope to do in their legal writing: to identify, simplify, and clarify. To identify, the book is valuable in my area of interest because it identifies some gaps in Philippine law on how international rules are domesticated. One gap pertains to the status of executive agreements under Philippine law, as pointed out by Professor Rommel Casis. Judge Pangalangan points out in his book that there is no textual basis in the Constitution for the President's power to enter into international agreements without Senate concurrence. Another gap concerns the role of the Congress under Philippine law in making treaties binding as Philippine law and in the country's withdrawal as a party to treaties like the Rome Statute. Judge Pangalangan notes that the constitutional text is silent on the matter of the President's power and the Senate's role in treaty withdrawal. There are other gaps in this area of Philippine law concerning the intersection of the two legal systems. One possible area of additional research would be the status of rules of international law in the Philippine legal system, their place in the legal hierarchy, and the possible effect on existing Philippine legal rules. The book also identifies some patterns in the Supreme Court's rulings and reasoning in Philippine cases applying rules of international law. One pattern identified by Judge Pangalangan is the Supreme Court's differential attitude towards the President's decision on whether an international agreement shall be a treaty under Philippine law or a mere executive agreement. To simplify, as previously noted, the Supreme Court's analysis of how international rules become Philippine rules has been oscillating, even arbitrary. Are international agreements domesticated through the incorporation clause or through the treaty-making clause? Are international agreements domesticated into Philippine law, even if the Philippines is not a party to them? Are treaties on the same level as statutes, or do statutes have primacy and cannot be modified by a treaty? The judiciary's answer to these seemingly simple questions have been constantly changing like the shifting sands. This has confounded and confused many Philippine law students, even Philippine lawyers and judges, and even lecturers in international law. Dean Magaliona's materials that Judge Pangalangan has carefully selected provide an easy reference for those who wish to understand this area of Philippine law and possibly apply it in the cases that they handle. I will certainly include this chapter on sources of international law in my list of required class readings. And finally, to clarify, the effort to clarify what seem to be conflicting judicial decisions based on an oscillating, even arbitrary approach requires mastery of legal theory. And this, I think, is where Judge Pangalangan's chapter on sources of international law makes its biggest contribution to my area of interest. Professor Rommel Casis has described this theory where Judge Pangalangan split the question regarding the status of international law in the Philippine legal system with regard to the binding nature of international law and with regard to the domestication of international law. I will focus on another framework of analysis introduced by Judge Pangalangan. Judge Pangalangan proposes the novel theoretical framework of examining the judiciary's decision involving international law on two axes. The first axis of analysis is what he describes as the vertical axis between national sovereignty and international governance. The second axis of analysis is what he describes as the horizontal axis between democratic governance and the institutional constraints of republican governance. Judge Pangalangan's dual axis framework is certainly worth examining, and I foresee that this will inspire many legal journal articles. In closing, I wish to thank Judge Pangalangan for his valuable contribution, and more importantly, for his continued support for international law scholars here in the Philippines. I look forward to further legal writings by Judge Pangalangan. Thank you.
Thank you, Professor Raj. We invite our audience to contribute to the discussion. So we have the Q&A and the chat boxes open. Please post your questions there. And they may be directed to our distinguished author, Judge Raul Pangalangan, or any of our panelists. Moving on to another chapter of the book on Philippine territory, we're honored to have with us as our next panelist, Dr. J.L. Batongbacal. Professor Batongbacal is the director of the UP Institute for Maritime Affairs and Law of the Sea. He teaches courses on property, obligations and contracts, and law of the sea and natural resources. A graduate of the UP College of Law, Professor Batongbacal holds a master's degree in marine management and a doctorate in the science of law, both from Dalhousie University in Canada. His graduate degrees were acquired under scholarship grants from the Canadian International Development Agency and the prestigious Pierre Elliott Trudeau Foundation, respectively. Taking advantage of his graduate training in interdisciplinary and multidisciplinary studies, his career spans a diverse field of marine policy research. These have included marine territorial and jurisdictional issues, international maritime boundary negotiations, high seas fisheries, seafaring, shipping, marine environmental protection, coastal resource management, maritime security, and archipelagic studies. Dr. Batongbacal was the legal advisor of the technical team that prepared and successfully pursued the Philippines' claim to the continental shelf beyond 200 nautical miles in the Benham-Rise region. The claim was made in a submission filed with the Commission on the Limits of the Continental Shelf pursuant to the provisions of Article 76 of UNCLOS. The CLCS recognized Philippine jurisdiction over the Benham-Rise region in April 2012. We welcome Dr. Batongbacal.
Thank you. Thank you. Judge Pangalangan, Professor Pangalangan, his better half, members of the audience and colleagues in the college, as well as those in the audience. Good morning, good afternoon, good evening, or good day, whichever part of the world you are in right now. Thank you for inviting me to this very important colloquium and to discuss a particular chapter of the new book of Judge Pangalangan. Of course, people might have noticed that my own work deals a lot with the Philippine National Territory. So this is really something that I can speak to. And I am very pleased to say a few words about the contributions that Dr. Pangalangan has made by including this very important chapter in this collection of international legal materials on the Philippines. In the first place, it's not that easy to find a book which contains precisely these kinds of documents, international legal documents that deal with the Philippine National Territory. Second, actually, the study of the Philippine National Territory requires the familiarity with so many legal and historical documents. It requires a familiarity not only with the law and the principles of law, but also their context and application throughout our history, both as formally documented and as we continue to practice it. Okay. And this really makes it difficult to really understand the evolution of the national territory and the concept of the Philippine National Territory without going through all of these various documents. And maybe that's one reason why even in law school, everyone here probably will have noticed by now that we do not really deal at length with the concept of the Philippine National Territory in our own constitutional law subjects beyond perhaps a perfunctory section on Article 1. But actually, Article 1 in those two sentences, it sort of conceals a very long list of documents and materials that one must wade through in order to fully grasp what is implicitly and explicitly included in that very simple term, the Philippine National Territory. a study of the national territory would probably merit at least a 2-unit course, in my opinion, with an extensive syllabus of all of these various international as well as municipal legal documents, no? So that you can really appreciate this very simple but simply worded but very complicated topic. However, no, one of the very good things that Judge Pangalangan has been able to do here is, no matter how many these documents are, there are a few that are in a way more important than others. You could say that these are the keystone documents. These are the basic foundations around which all the other documents rely. It's like the starter set of a Lego set, no? But by having these documents collected in one concise and succinct chapter, the reader is able to now have the foundation, the necessary foundation to begin to understand now this very complicated concept we now call the Philippine national territory. Judge Pangalangan has been able to very judiciously and carefully identify and select the really foundational documents here. When one could say that they're like the eyes of the storms of legal controversy sometimes, no, when you look at these documents. So, for example, the Treaty of Paris of 1898. No? That is indeed one of the sources of all of the legal complications and all of the legal problems we've had ever since the birth of the Republic. No? Because of the way it has been interpreted, reinterpreted, misinterpreted, and even applied. And finally, that controversy, the controversy that the 1898 Treaty of Paris created about the very definition of our national boundary, the territorial boundary of the Philippines. That was a controversy that kept brewing, that kept on blowing until 2011 practically, okay? Until the decision in Magallona versus Executive Secretary, which is also included in the collection, finally brought some consistency, tried to resolve the burning question about what is the status of the so-called Treaty of Paris lines, which date back to 1898, and how they fare in light of modern international law, particularly how they should be understood in light of the United Nations Convention on the Law of the Sea. Okay, and so Judge Pangalangan very properly identifies the key issue. Instead of giving us the entire documents, he goes straight to the point and shows how Magallona versus Executive Secretary clarified the status of these Treaty of Paris lines, so that this serves as a prelude to the next big document, the next controversial document, the controversy for which is now still raging in the international community, and that is the South China Sea arbitration of 2016. Okay, now again, instead of giving us the 501-page decision, and going through each and every detail, books have been written just just to distill that decision into something more digestible. But Judge Pangalangan goes further and zeroes in on the most important aspects of which are relevant to the national territory and the concept and definition of national territory now. And in addition, he reviews the most recent developments about the South China Sea arbitration, which, as you know, since its promulgation in 2016, has been very hotly debated and contested, not only because of the losing parties' initiatives, but also because there are some legitimate questions that are indeed raised by this very innovative and trailblazing decision. Okay, but by also including a discussion of the so-called Battle of Note Verbals, which occurred just last 2020. This was an exchange of diplomatic notes in the Commission on the Limits of the Continental Shelf, which, although it might be seen on one hand as some kind of it should have been some irrelevant or innocent process because it doesn't deal with the national territory, nor does it deal with nor does the Commission on the Limits of the Continental Shelf deal specifically with laying down boundaries, maritime boundaries. No, it's only concerned really with the extended continental shelf. But the CLCS process became the venue for this exchange of nos verbals, which expressed or reiterated or perhaps strengthened positions that have been reached by members of the international community concerning the South China Sea arbitration, which in turn strengthened the Philippines' position on its maritime boundaries, particularly the boundaries, its maritime zone boundaries in accordance with UNCLOS. And in so doing, they reinforce, in a sense, these note verbals, which for the most part express support for the South China Sea arbitration. They then indirectly express support for the Philippine position now on the extent of its maritime boundaries, its varied maritime boundaries at sea, particularly its EEZ boundaries, its continental shelf boundaries, as well as the boundaries of the national territory, the territorial sea, its archipelagic baselines and archipelagic waters. Okay? So by identifying these particular passages, particular extracts, we zero in, the reader gets to zero in on the most important aspects of these lengthy and voluminous documents, and takes away the most important gist, all of which support our understanding now of the Philippine national territory, so that Article 1 is no longer just a reading of 2 sentences in the Constitution, but you now have the additional context of these foundational documents, which, if you're then interested, you can read on, follow up into more detailed studies of the many other relevant and related documents and practices, which, as I mentioned, is actually embedded throughout a long history. Okay, so that is really, I think, the importance of this particular chapter. It serves not only as a focal point, but also as a takeoff point for people who have some burning questions about the nature, the extent of the Philippine territory, but also would like to get started on researching it even more. Okay, and having this as a foundation, I think, is very, very handy, very, very important, for anyone who might want to have an interest in researching the national territory in any particular aspect of it, particularly, especially its implementation now in the context of the Philippines being a member of an international community. Now, one other thing that I noticed in the chapter is that Judge Pangalangan has brought up documents that bring to light and provide some context and clarification as to, say, differences in or problems in legal interpretation between the international community or international law and national law. But he also points out certain documents that actually bring up questions about the Philippine national territory as a whole vis-a-vis territory, shall we say, or areas of subunits of the Philippines, particularly areas claimed by the indigenous peoples, which is, I think, the first, and this, I think, is the first time I've seen it really dealt with in a book or article or a legal publication, because it's often overlooked. It is not seen from an international lens. It's usually discussed perhaps in the context of national law and implementation of the Philippines of perhaps international commitments on human rights in relation to indigenous peoples, or implementation of the constitutional policy about indigenous peoples. But by bringing it up here in this set of documents, Judge Pangalangan actually brings to light again, an often overlooked aspect of the Philippine national territory, and that is that the issues that we have in definition and interpretation of national territory are not solely concerned with, say, differences with international opinion or opinion of other countries, but also in differences between concepts of territory between the conventional, traditional, and the existing or prevailing national legal system, and that of something more primordial, something the concepts of indigenous peoples no? And those that are embedded in indigenous people's customary laws, no? And that is something that, from my perspective, actually merits even further legal scholarship and study, because it's an entirely, I would say that for this reason, it would open up a possibly new avenue of research, no? Although we have quite a bit of experience and writing perhaps already on Indigenous Peoples Law and the NCIP and the Indigenous Peoples Rights Act, we don't have it from this particular approach of seeing Indigenous peoples as in a way a potential subgroup with a territorial claim vis-a-vis the Philippines, of which it is part, no? And that's why it's very important. Okay. So in conclusion, let me just go through the questions then that were given us, no? How does this chapter figure in our particular field of expertise? Well, as I said, it is a very important source document. It's a very important reference to be able to refer to, you know, any newcomers or researchers, that this could be like your starter set, no, from which you can take off on your inquiries. The substance is as I already mentioned, no, it makes that contribution not only of giving you that concise summary and foundation, but also sheds light on another aspect of the national territory and its differences, the differences between the concept of the national territory vis-a-vis indigenous peoples groups and their concepts of say communal territory, no, basically ancestral domains. And then with respect to the impact, I am sure that because you have these qualities in these chapters, no, and this is only one chapter among many, no, I am sure that this will have an effect on the international legal landscape, because for one thing, foreigners, foreign legal scholars will be able to have that glimpse, no, once they see the foundation, then they will have a better understanding of how to research the topic and how to understand, no, the context of other related and subsequent documents. And that will then also enable our own scholars here on the national setting to also have a deeper understanding, to have a more nuanced and contextualized interpretation of our laws relating to the national territory. So thank you very much again for this opportunity to speak on this, and that's all I'll say for now until the Q&A. Thank you very much.
Thank you very much, Dr. J. Batongbacal. The next presentation will deal with a chapter of the book on human rights cases from the Marcos dictatorship. Sharing his insights on the matter, we're honored to have with us today Professor Dante B. Gatmaytan. Professor Gatmaytan teaches constitutional law, legal method, and local government law. In addition to holding an LLB from the UP College of Law, he has master's degrees from Vermont Law School, where he graduated as cum laude, and the University of California, Los Angeles. Writing on a wide range of issues, which include the environment, gender, the judiciary, and the intersection of law and politics, his works have appeared in the Asian Journal of Comparative Law, the Oregon Review of International Law, the UCLA Pacific Basin Law Journal, the Georgetown International Environmental Law Review, and the Harvard Women's Law Journal, among others. Professor Gatmaytan has also authored books including Legal Method Essentials, Local Government Law and Jurisprudence, and Constitutional Law in the Philippines, Government Structure More Equal Than Others, Constitutional Law and Politics, and Underclass, Public Interest Law Practice Perspectives. We welcome Professor Gatmaytan.
Thank you, Attorney Paula. Judge Raul, thank you for the additional pressure during your introduction. I needed that. Professor Beth, Dean Vistan, and the faculty, my fellow panelists and guests. When I received the invitation to become part of this colloquium, I immediately said yes. Of course, I was very, very excited. because I am a fan of legal scholarship and the exchange of ideas among the academy, members of the academy. And this excitement turned into joy when I received a chapter on human rights cases from the Marcos dictatorship. This is because the chapter deals with something that is reflected, I think, in election season. You know, what is fake news, the role of courts, etc., and the fact that this chapter intersects with my own research interests. That is the role of courts, or what I call the history writing function of courts. So, Judge Pangalangan's approach here, I think what he was trying to present in chapter 7 is how we can use American courts and Philippine to do, enforce the rights of human rights victims during the Marcos regime. And the thesis, I think, so far as this chapter is concerned, is that there is a conflict between those victories and the way they are implemented by local courts. I mean, the assertion that ill-gotten wealth should take precedence over the rights of human rights victims. And in this effort, just as he did with the other chapters, he presents excerpts from the materials to enable the readers themselves to come to a conclusion, what really happened. And I excerpted this part from the book. I'm sorry, this is not the excerpt. And I'm sorry. What I'm trying to say, what I'm trying to do in this presentation is show how this book can serve other goals beyond its academic function, which is to teach law, and that because we have a candidate for president who is relying on his father's record in lieu of his own campaign platform of government, and this discourse, the election discourse, is clouding, is clouded by historical revisionism or denialism. That's what we are seeing right now, because we're now entitled apparently to our own truths. And this is why I think Judge Pangalangan's book becomes indispensable, because it helps. That's a role to play in this situation that we have now. I will use a lot of images because I'm just cooler than the other panelists. Okay, I mean they know that. It's not even a contest. And look what I'm talking about here. It is Bongbong Marcos who is claiming to be the victim of fake news. Right. So on one hand, you have one of the candidates who says that he's a victim of fake news, and on the other, he appears to be, or his camp appears to be, the proponent of fake news, and this is why Twitter has suspended hundreds of accounts supporting Bongbong Marcos's presidential bid, apparently because of a violation of his rules on manipulation and spam. So this is where we are right now, where everyone can assert his or her version of the truth. And of course, the passion we exert in elections has an effect on what really happened during martial law. And these are some of the figures that are circulating right now in social media. And 70,000 imprisoned during Marcos's the martial law, 34,000 tortured, 3,000 killed. And if you don't like Rappler, you look at other media sources. I think this is GMA, where they talk about ill-gotten wealth. How much of it is there? How much of it we've recovered, etc. And we're not even, the blurring of truth affects how the economy was during Marcos' time. on one hand, one camp saying it's the golden years of the Philippines, the other side saying it really wasn't. So again, we have a problem. There are other things. There are other things that are getting buried in the social media war. Pro Marcos, people asking, well, if she's guilty, then why is she not in prison? Which brings up the necessity of reading the Sandigan Bayan cases, finding Mrs. Marcos guilty. Apparently, the Marcos estate has a debt in the amount of, well, how much of it? 203 billion, right? But look at the response of the Marcos camp. It's fake news, even if there is a Supreme Court decision saying exactly that the estate owes that much to the Republic of the Philippines. Look what came up yesterday. ISCO party asked Supreme Court for certificate of finality, but the estate tax says due on the property. What interests me about that last part is that you go to court. I'm not sure what the cause of action is in this case, because I didn't read anything else, just the social media part. But it shows how we rely on courts for the truth. Apparently, if the Supreme Court certifies it, then it is true. So I'm not sure what kind of case that is, but that's what they're planning to do. And I bring these up because I would have thought these are questions that can be easily settled if you knew what to read, if you knew where to go. And that is why, again, this book is important. This is from chapter 7. And Judge Raul talks about why the judicial record is crucial. And the first one interests me the most. In a national milieu where where truth is elusive, these records are fact-based and have been vetted by disinterested courts abroad. So if the question is violation of human rights, I think the chapter presents several cases where claimants have won and courts actually enumerating forms of torture that were inflicted by the Marcos administration on dissidents and those who disagreed. And that is the value of, the value of the case is because it tells us after judicial proceedings what happened during Marcos's time. Okay, and the rest of the chapters where, as I explained earlier, demonstrates the overlap between two sets of cases, the human rights victims' claims and the recovery of ill-gotten wealth, and how those two collide, even at present, I think, if I'm not mistaken. And foreign litigation efforts in the United States, etc. But it's the first one really that interests me. And in my own research, in other words, I agree with Dean Pangalangan, because in my own research on this one is on Campo, on the Marcos burial case. You have literature that says law constructs a history that it wants to present as authoritative. Okay, law traffics the slippery terrain of memory as different versions of past events are presented for authoritative judgment. In the production of judicial opinions, law reconstructs its own past, tracing out lines of precedent to their compelling conclusion. It is not true, as the court said, Supreme Court said in Ocampo, that this is purely a legal issue, because decision writing has the effect of writing history, has a way of presenting the truth, which I think is consistent with what Judge Raul is presenting. Judicial decisions are products of social memory. They are one of the many social institutions that produce social memory. What happened really in the past is something that you can discover upon reading a court decision. And this is why the law is an important instrument in struggles for recognition of different victims of past injustices, because law formalizes and legitimizes particular narratives of victimhood. The law turns private memories into public narratives. And this is why I think the US case is cited on human rights claimants is important, because their story is recorded. And this is just true for human rights victims. It's true for virtually all international tribunals where mass atrocities were committed. Those courts have an additional function of presenting what exactly happened so that we cannot deny it. And just to give an example on that is probably the most famous of these international tribunals, where we tried the Nazis for crimes against humanity. See, and in the Nuremberg trials were staged to satisfy the requirements of both principal judgment and historical tutelage. In other words, you not only do you arrive at a judicial conclusion, but you use it to teach. You use it to teach history about what happened during the Second World War. The trials were called the greatest history seminar ever held in the history of the world, that will provide an authoritative and impartial record to which future historians may turn for truth. These trials are designed to show the world the facts of astonishing crimes and to demonstrate the power of law to reintroduce order into a space evacuated of legal and moral sense. Again, emphasizing my point about why a judicial record is important for truth. And it's astonishing because historical revisionism on what the Nazis did, I think, started, if not started, well, you know, it's targeted Nazi war crimes. They are denying that any of that happened. They're denying that Hitler was that evil and that only his subordinates were responsible for all the atrocities, the death of 6 million Jews. So on one hand, you've got the role of courts, the history writing function, and then attempts to revise or deny these atrocities from the other side. My view is judicial record stands in the way of revisionism if properly executed, because as I said earlier, I've got a huge issue with the way the Supreme Court, our Supreme Court, decided Ocampo versus Enriquez. I think the court abandoned its history writing function for political considerations, I guess. And that is why Mr. Marcos is now buried in the libingan ng mga bayan. But I also think local courts can be disinterested as well. And that is why we have Sandigan Bayan decisions finding government officials guilty of graft and corruption. So it is not a monopoly of foreign courts. Although the temptation to classify them as such is understandable, because they are disinterested in the sense that the parties are not, you know, Americans. I mean, in other words, the progress against Mr. Marcos as a state works in part because they are American courts, not persuaded by things other than the rule of law. And we know this, that courts can malfunction in that sense, because this is just a way of describing Javeliana versus executive secretary, where the court's role in legitimizing the authoritarian regime becomes indispensable. So courts, while you can preserve the record of human rights violations, of atrocities, can in fact be used the other way, you know, to justify probably the worst way to ratify a constitution. You know, it can violate every provision of the Constitution, but the Supreme Court can still say there's no longer any obstacle to the 1973 Constitution. I think it's a duty to remember history. You know, in other words, to find out exactly what happened. And that means getting away from TikTok and actually reading you know, legal historical material so we can be informed of what happened. And that's the contribution of this chapter, the book, I assume. But this chapter in particular, and that's the point. See? These efforts, curating these materials, informs the election discourse, because I find out that trolls tend to stop when you direct them to official documents proving the atrocities of the Marcos regime, because they can't answer it, they can't fight back. So of course, we have as academics an additional function of translating academic works like this into something useful, something that can be used by ordinary citizens. That didn't sound very nice. By other people from other disciplines. Yeah, right. Because let's face it, we're all excited about the way the materials are simplified to an extent, because it helps our work when inform the public about legal history. In fact, before I forget, I want to thank Judge Raul for writing this chapter, because it saves me the trouble of writing it myself. And and like everyone else in the panel, I am going to assign this chapter, and probably the chapter on national territory, because it explains why the Constitution was written that way. Right? Why the preamble is written that way, why it talks about rule of law, and why we had to strengthen the Bill of Rights, why we had to include the provisions of social justice, limitations on the power of the executive, so that they can have a context, students can have a context or why we changed the Constitution. And now my outline will be dotted with Judge Raul's work. Thank you. And I'm looking forward to our Q&A.
Thank you, Professor Gatmaytan. And we're now down to our last panel presentation for the day. Leading the discussions on the chapter of the book on international criminal law, we're honored to have Professor Michael Tiu Jr. Professor Chu is the head of the International Criminal Law Program of the UP Institute of International Legal Studies. He teaches courses on constitutional law, administrative law, and torts and damages. In addition to his Juris Doctor degree from the UP College of Law, Professor Chu has a Master of Laws in International Business Law from the Central European University, where he graduated with highest honors. After spending some time in private practice doing criminal and commercial litigation, Professor Chu engaged in both academic and public service-oriented work with special focus on constitutional law, human rights, and international law. As head of the ICL program, Professor Chu supervises the ILS initiatives to diversify legal scholarship on international criminal law developments and issues affecting the Philippines. Currently, Professor Chu also serves as the head of the Information and Publication Division of the UP Law Center. So welcome, Professor Mike Chu.
Thank you, Attorney Paula, and good afternoon, good morning, good day to everyone, wherever you are. I want to begin by thanking Dean Carlo Vistan, Professor Rommel Casis, and of course, Professor Elizabeth Aguiling Pangalangan for organizing today's colloquium, which gives us the space to refine our ideas and be in this exchange. And I would say that I am probably the most glad to be here, considering the panel who have been my professors and who are intellectual giants in the profession and in international law. So I thank you for inviting me to this colloquium. And I also want to thank my co-panelists who we will be engaging in a discussion later during the Q&A. But most especially to Judge Raul Pangalangan, who was my professor in Constitutional Law 2, the Bill of Rights, a course that I also teach now. And the delight that I experienced reading chapter 10 on international criminal law in his book, because there I encountered again the Professor Pangalangan, the scholar who was my professor in that course, and who always discussed our con law cases in the context of the political realities of the time in which those cases were decided. And that was a pretty good starting point for my reflection on the chapter, considering that it made me realize that perhaps, and not too many people may have realized this at the start, that perhaps international criminal law, or the ICC in particular, would be at the center of populist politics in this country. Perhaps only known to those who follow criticisms on international criminal law against the ICC and its alleged Western bias and the norms that it used that's not particularly in line with understandings in the third world or the global south. And it is in that light that I start this presentation with reflections on the rule of law and the role that the chapter on international criminal law in Judge Pangalangan's book plays in reaffirming, well, first of all, identifying our participation and reaffirming our commitment to the rule of law, and in particular to our membership in the international community, and our sharing of norms with all the other participants in that community with respect to accountability and accessible and impartial justice, which would be from the definition of rule of law that the Rule of Law Index uses. And that reinforcement comes with things that follow, like the formation and fermentation of norms and accountability. And later on, we will talk about the Philippine contribution to the fermentation of those norms, and how, more importantly, these norms are shared by the members of the international community through what we call the International Criminal Justice Project. And it is important to think of that in light of populist politics, because there is an ebb and flow in that regard, where you have a relatively peaceful time, and you think about injustices that occur when atrocities happen, and then the seeming rejection of these norms when you engage in electoral exercises that capitalize on a polarized electorate and this anti-elite idea of populist politics. And what is particularly important in this chapter, which would not be obvious if you don't really go into the detail and don't think about the context in which it is written, is that it pushes back on the realpolitik of the international community. And it tells you a story of a rules-based order and the possibility of that project, which is a continuing one. So it's something that we're continually working towards. And it doesn't give us a given politics by big states and how they determine norms, because as we can see through the populist politics that we are now experiencing all over the world, or have experienced in the past couple of years, that there is a pushback. But this chapter delivers a different kind of pushback, in that pushback against that pushback, so that we can see a possibility of a rules-based order. And it also reinforces when it talks about how domestic courts have decided international criminal law issues, or issues involving ICL materials, that international law is law in this jurisdiction. So that is a particularly important point to make. And that point is made by the chapter because of its effective use of history. And in fact, the forward also identifies this particular advantage when it says that the chapter, the book in general, pushes back against the problematic tendencies of major powers and the dominant voices, but also pointing out that our hands are not clean in this regard as the Philippine state. So we also have our own conflicting tendencies. And in this regard, we want to think about our voice in international criminal law as an Asian country, and as a country that has also gone through the colonization and decolonization process, and of course, the third world approach that we can use in analyzing these issues, and how we are able to have a unique contribution to international criminal law development through doctrine and practice, as we can see later in the command responsibility doctrine, and our resistance to either doctrine as well, based on the third world approach, and the practice of other states in that regard. So I would say that the chapters identifies our substantive contribution to international criminal law with respect to concept and practice. And one other key point to be made is that the chapter also tells us that the international is local and the local could be international. And what do I mean by this? Not just the contribution of our courts and our practice to the shaping of international criminal law, but also how we have understood international criminal law concepts as they may be novel or actually interpreted not to be novel because we've already had these concepts in our criminal law regime in the first place. And one example of this is our participation in international lawmaking, particularly with respect to the domestication as well of that international law through the IHL law, which Judge Pangalangan identifies in the chapter. And the point to be made here is that this mirrors and this also reaffirms our commitment to fundamental values that members of the international community share. And this is with respect to also exacting accountability to the most serious crimes of concern to the international community as a whole, which we find in the Rome Statute, as well as in our domestic law as identified here, which would be RA 9851, among others. And this and the chapter also talks about the long history in this regard, that actually we are not new to this discourse. In fact, one case which was a case about piracy and how that's penalized, reveals that we have all along participated to this discourse by reinforcing the nature of international crimes, as in that case it was piracy, and universal jurisdiction, which is an important concept in this field. And what the chapter of this book really does, especially for me, is that it makes sense of the cacophony of voices on international law issues, particularly the voices that's already also identified as an issue by my co-panelists of domestic courts and how they interpret concepts. Even just the step of domesticating those concepts is highly contentious and also oscillating, as Professor Raj mentioned. International tribunals in the perception of those concepts. Also with respect to history, where the chapter identifies the contribution of a Filipino judge in the tribunal, the International Military Tribunal for the Far East, the Tokyo Trials Tribunal, and how that has influenced the debate on ICL, in ICL, and in fact referred to specifically by other jurists in other jurisdictions as well. So this demonstrates the tools and mechanisms that Filipino jurists and courts have used in this area of law. And one case that Judge Pangalangan identifies in the chapter that also supports this point is the Kuroda case, which actually, the bottom line would be that even if in that case the court said that we have not been signatories to the Hague and Geneva Conventions at the relevant time in which the issue arose, we've had these principles all along because they are part of the law of our nation, as the Supreme Court has discussed in that case. And we go to the significance of the contribution, and I said it was substantive because of this example, the command responsibility example, a doctrine that arose from cases of Philippine origin that eventually ended up in the U.S. Supreme Court, and the U.S. And Judge Pangalangan frames the issue in this regard in his chapter as how it is stated here. But more important to me was how Judge Pangalangan illustrated the use of this doctrine in the Amparo cases, which is a recent innovation, fairly recent innovation of our courts in the protection of human rights, and the development of the use of the command responsibility doctrine in court decisions from the margins to the center. And I say that because Judge Pangalangan identifies that while in earlier cases, the command responsibility doctrine was just discussed in a concurring opinion, I think of Justice Calvi Morales in the Rubrico case, eventually it found its way into a majority opinion, which was also written by Justice Calvi Morales in the Boac case. Another point that could be that could signal possible innovation in this area is something that Judge Pangalangan also identifies, which is the NDFP's acceptance of the applicability of Protocol 1 of the Geneva Convention ahead of the PH government, meaning that it was willing to take on the responsibility, command responsibility for the actions of its subordinates, for the actions of the subordinates of the leadership of the NDFP. And that's particularly striking to me as a point of innovation, as a possible point of innovation, because of the issues now before the International Criminal Court with respect to vigilantes and how to navigate that area where it's not clear really whether there was a state actor or the state leadership had a role to play or what role it did play in a particular set of facts. And just to illustrate this contribution, it found its way again in the Yamashita decision of the US Supreme Court, and I highlight it here. I apologize for the text heaviness of my presentation. In this regard, I agree with Professor Dan that he's certainly cooler than me here. But this is an as-applied challenge, Professor Dan. And of course, how it reached or it found its way to the Bemba case and the trial judgment there. And from just a general statement of command responsibility, we now have a codification of this doctrine in the Rome Statute and an ICC materials decisions that outline elements that make this more comprehensible for courts. And therefore, that I think is a significant contribution of this jurisdiction. And of course, we can't speak about international criminal law without looking at the relationship of our state and the ICC, which Judge Pangalangan characterizes as eventful. And his framework of analysis here is particularly useful in the way that he looks at the relationship from the domestic legal system and our treatment of the Rome Statute and the dilly-dallying that happened there before it finally became effective, and also looks at how the ICC could apply the Rome Statute in the current issues before the court involving the Philippine states. One other important contribution would be the Hernandez Doctrine, which students of criminal law, the first-year students who are watching us today would be very familiar with, and the absorption of common crimes in the crime of rebellion, but how that could change because of the decision in Ongwen, which was also participated in by Judge Raul C's capacity as a judge of the International Criminal Court. And you can see the objection there with respect to nebis idem, or the double jeopardy as more popularly known. But the point that Judge Pangalangan makes is in the concurring opinion of Justice John, and how that could be an exception to the Hernandez Doctrine when we're talking about crimes against humanity. The same acts could be the basis for the prosecution of that. And so I come to my final points, which would be the contribution of this chapter is significant because it exposes the misreading and undermining of international law by our courts. Of course, the chapter also speaks of the important contributions of local courts in clarifying certain issues. But really the striking thing for me was the misreading and undermining of international law by decisions like Pimentel, where the court made a distinction between signing and ratification, and rightly Judge Pangalangan points out that these are not really, the doctrine there would be incorrect in light of how international law understands signing and ratification. And I would say there is support for that because international law just treats these two things, ratification in particular, in reference to a local procedure, but that local procedure we know doesn't require the executive signature after the signing of its representative. And of course, the alliance of the executive and the courts there, as Professor Dan earlier mentioned, with respect to deciding cases and deference to the foreign policy powers of the president. One other thing would be the incorrectness of the Pangilinan decision with respect to finality and effectivity in relation to its ruling on mootness in actual case or controversy. So really this is a rich chapter. Of course, the entire book is rich in contribution to the development of this field. But I then outline the ways forward that this chapter makes us realize, which is the revisiting of the role of the Philippines in this project, and how we can transcend the politics of the time to reaffirm our commitment to international criminal justice and how to navigate this effectively, because we all know that it's not easily done, could lead to our rejoining of the Rome Statute regime again. But really the important thing is that it induces reflection on how our domestic courts view and apply international criminal law. So again, I thank the organizers and of course Judge Pangalangan for his important work in this regard.
Thank you very much, Professor Chu. We invite again Judge Pangalangan for his reaction and thoughts on the points made by our panelists, and then we'll invite the rest of the panelists to join you for the Q&A.
Thank you so much, Paula. I'll try to keep this as short as I can. First of all, I'll go up by, in terms of the topics, I'll start with sources of international law. You know, I'm so glad that for both Rommel and Raj, it is their favorite topic in international law. Because in fact, when I went abroad to study, I realized that the classic treatment of the discipline, all the classic professors in the discipline would actually spend almost half the course on sources. Sources was it. And so I'm so glad that I have found kindred souls in the discipline here in our country. I'm glad that Rommel used the term the overuse of the incorporation clause by the Supreme Court, and in response to both Raj and Rommel, the fundamental distinction I made between what Rommel said called the binding effect internationally and the domestication of international law. That is actually from Dean Magallona. And I see this chapter in the book as my own tribute to the scholarship and to the legacy of my own professor in public international law, Dean Merlin M. Magallona. I recall Raj using his flowchart in one of the forums in the LLM program, the flowchart on the use of Filipino lawyers of international law and the way they would apply the sort of the sequence of questions that they must ask when they are called upon to apply international law domestically, and the intersection between the discipline of international law and Philippine domestic law. Just by way of closing on this chapter, as Rommel indicated, it should provoke. It is my hope that it will provoke a future scholarship in such an interesting area as sources of international law. As regards the discussion on territory, I'm glad that Jay was rather too modest when he spoke of the Battle of Note Verbales before the UN's Committee on the Limits of on the continental shelf. I think Jay should have mentioned that he was part of that battle. He was I think the Philippine filings in that before that UN commission contained a lot of Jay's contributions. And the one thing I would like to mention on this topic, as I'm sure Jay will attest to, is that in international discourse today, it can be a lonely task to be a Filipino lawyer advocating one's position vis-a-vis, let us say, face it, the hegemonic presence of China and China advocates in many of these gatherings. Of course, we are joined quite often with fellow speakers from Indonesia, fellow speakers from Vietnam, but I think that we have a long way to go in projecting the Philippine position in many of these international gatherings in terms of our presence. But I think the starting point there is for us to actually educate Filipino lawyers, Filipino law professors about the South China Sea award and its various implications. Going to the Marcos chapter, I must tell Professor Dan Gat that it was almost like an act of hope for me writing this chapter. I hope and I trust that people are capable of rational discourse and fact-based debates. In fact, Dan, when I was designing the chapter, I designed it as the first part on human rights abuses and political repression was about stolen lives. And then the next was on stolen wealth. And then the last was stolen truth. And for me, it is actually a persistent dilemma for me as a Filipino legal scholar on whether I should discuss an issue solely from the standpoint of law or to what extent I will bring in the historical perspective. In fact, even for the book, my half the chapters were on history, on historical moments, and the other half was on traditional legal doctrine. And I think at some point in my career, I just realized that these are two things I'll have to attend to in the course of my work. But yes, there is an epistemological gap in the discourse here. We have political partisans who prefer to ignore the truth, prefer to ignore facts, and it is my hope that the material I present will allow them to appreciate it fully, that foreign independent courts who have nothing to do with the Philippines actually saw and confirmed the repression and the abuses that we speak of. And finally, to Mike, I am so glad, Mike, that you focused on the place of normativity in legal discourse. Back to what Raj mentioned earlier as my interest in legal theory. It is by putting the debate of ICL back to firm legal footing that we can avoid the excessive politicization of the ICL debates in the Philippines. Because exactly as Mike did, it is not just vis-a-vis the ICC, it is vis-a-vis as well the rebel groups in the Philippines who have their own ICL and IHL issues that they raise against, in this case, the Philippine government. And also by affirming normativity in this discourse, we actually enrich the Philippine contribution to the debate. Yamashita is our signal doctrinal contribution of command responsibility in international law. But even the Marcos cases will actually extend the application of command responsibility outside a criminal proceeding, because the Marcos proceedings were tort claims for damages. And American courts said, well, we will extend the principle of command responsibility even in this area. But by way of closing, I am so glad that all our commentators, and I thank all of you for taking part here, that all of you have mentioned that the hope that this book will simply set the stage and provoke more writing and more reflection in the Philippines. It is my hope that we can, from this book, the younger faculty, our LLM students, our own students, our moot court veterans, can pursue topics that I have indicated in this book and and for me, it will actually magnify the effect that I hoped, which is to enlighten public debate in the Philippines. Thank you so much.
Judge. Before we continue with our Q&A, I would like to request all the speakers that we had, including Prof. Beth and Dean Carlo, to please open your cameras for a group photo. And I'd also like to request IPD to spotlight all the speakers before we take the photo. Okay. Ready? Big smiles, everyone. Happy Tuesday. Okay, I think we've gotten a photo of everyone. Thank you. We'd like to invite the rest of the panelists to join Judge Raul for the Q&A. And we did receive quite a number of questions. And we'll start with one that specifically deals with the presentation of Professor Gatmaytan. So the question goes, Professor Gatmaytan mentioned Nazi historical revisionism. What can we learn from the Holocaust denial or revisionism, and how can we implement or execute it in the Philippines, considering that many Filipinos may not have access to the resources that we have? And the question related to that really is, what are practical ways for the legal community, so lawyers and the academe, to address these issues?
Thank you. I have not studied the discipline from a historian's point of view, the responses. But I think one of the things I was trying to say earlier was that the court has a legitimizing function. And because of this, all groups try to control the membership of the court so that it can produce the truth that it wants. So, but I think members of the academe, lawyers, have this responsibility to write, just as Judge Raul did, to explain doctrine, to explain evolution of law, to enlighten everyone. I think the answer to fake news is more truth, and I think human nature in the end will side with truth. But it is our responsibility to make it known, and it cannot be simply because we say so. It has to be based on facts. It has to be based on evidence. And that is the function of law in this regard. I hope that's enough.
Judge or any of the panelists would like to add or build on what Professor Gatmaytan said? None? Okay. We'll proceed to another question, and this one specifically deals with the presentation of Professor J. Batongbacal. So there was an interesting discussion on the chapter Philippine Territory, linking the national territory framework with the concept and struggles of internal autonomy. As IP claims are predominantly and understandably governed by domestic law, how relevant or coercive are international instruments dealing with internal self-determination, such as the UN Declaration on the Rights of Indigenous Peoples, in resolving these claims?
Those are very relevant because, as you know, the problem of indigenous peoples laying claim to territories within states, no, is not just the Philippines alone. It's quite common among many other states. And in the United Nations, that is actually where the principles and concepts on how to deal with the indigenous peoples and their claims and questions of self-determination. No? The discussions and much of the scholarship actually took place at that level, no? In the international community, leading the UN to produce a line of documents on self-determination and indigenous peoples. And that then reflects back to the states and their domestic constituents. For the indigenous peoples who are already marginalized, no? Usually they're the marginalized groups within states, no? They need that kind of external support, not only to validate, but also to reinforce the correctness of their claims, no? to have the international community's recognition that they have rights vis-a-vis the states within which they are found, no, is something that helps in their struggle for self-determination. No? And it in a way it's how the what you call this, the classic formations of the state, no? The Westphalian state, how that sort of clashes with the indigenous concepts of nationhood. No, there's often not many venues and fora within which that clash, that tension can really be dealt with and discussed. Unfortunately, in the international community, there has emerged, no, one forum has emerged in the UN, no? And otherwise, the only other forums would be with non-state actors like NGOs and advocacy groups, or within each particular state where the voice of the indigenous peoples are stronger, where they're able to articulate it better and more strongly vis-a-vis the national governments with whom they deal. No? Often that's a very tough job, because they're marginalized, dihado na sila. They're always working at a disadvantage. And so the international discussions helps to strengthen and reinforce their local or national municipal discussions. So that's how I see it being related. And that's why bringing this up here in a book on international law, bringing up the tensions between Philippine indigenous peoples and the Philippine national government, no? Bringing it up in a discussion about national territory, no, is important and quite relevant. No?
Yeah, I have. Can I just jump in briefly?
Yes, Judge.
Paula. Oh, further to what Jay said about the limits of the Westphalian state vis-a-vis the voices of indigenous peoples. The irony in Philippine legal history is that when it came to the rights of indigenous peoples in Carino, it was the Philippine Supreme Court which was completely unsympathetic to the IPs. The Philippine Supreme Court, which was so legalistic, and the more enlightened view came from the US Supreme Court, from Oliver Wendell Holmes, who said that, you know, the colonizer comes in and kind of just overnight declare the natives to be trespassers in their own homes. And just one last factoid about that, and even our reliance on Carino versus insular government springs from two foreign interventions. The lawyer for Mateo Carino was an international law firm, Cuder Brothers, eventually became one of the largest international firms. They have been dissolved since. And finally, that this case was actually discovered for us by an American Peace Corps volunteer at that time, Owen Lynch, who eventually wrote his JSD dissertation on the topic. Just some interesting points on the role of the international vis-a-vis local debates. Back to you, Paula.
Thank you so much, Judge. This will be our last question, and this is open to all our panelists and Judge Raul as well. So the issue of executive agreements was brought up several times, and we do have some up-and-coming scholars in this area. Perhaps to enrich the scholarship in this discussion, as well as to encourage up-and-coming scholars to participate as Asian and Filipino voices in international law. Are there ways available to us now, or strategies that we can use to approach this issue to render clarity on how to go about an executive agreement and treating it under international law?
Rommel has written on this, so
Yes. How much time do I have? Well, I guess, you know, I avoided talking about it in the presentation because it would have taken too much time. I just said that the current policy, and I call it policy because I disagree that there's any law on this. The current policy on executive agreements really is not aligned with international law or any coherent legal basis. There are recent decisions that try to rationalize it, and that is the starting point. But I think Dean Magalona has a good point in his book that when the Constitution defines a word or uses a word like treaty, then it should be used consistently. That's just basic interpretation. I think there's a way to limit the application of executive agreements, perhaps to make it more palatable legally. But there has to be some strict controls. I think that might happen not so much on a legal level, but on, well, on an administrative law level, perhaps, because as I talk about this with, let's say, the DFA, there seems to be, well, I think we just need to have a greater clarity on the criteria for executive agreements, for example, because we cannot define executive agreements simply as, oh, it's any international agreement that does not require Senate concurrence. Well, that's exactly the result that we want to figure out. That cannot be the criteria for defining it in the first place. So I think any rational debate or resolution on the matter must come first from a good definition or a criteria for determining what an executive agreement is. And some would say that's already in jurisprudence. But the problem is the case law is not consistent. And I think perhaps the executive can exercise its power by finally giving clarity to what an executive agreement is, so that the judiciary can then follow and either confirm or clarify this position. But again, it's a long discussion, and that's all I can say given the time right now.
Can I add to what Professor Rommel said? So in trying to locate the issue on the status of the executive agreements, I think there is no question of its status under international law. No question about that. They're the same as treaties, right? The question really is the status of the executive agreements under Philippine law, whether they have a less preferred status in our hierarchy of rules. What's interesting is that the definition for executive agreements is founded in an executive order, EO 459 of 1997, which is not very not a very good definition. And also in terms of testing, whether the definition has really been practiced, whether the requirements of EO 459 have been met. There are a lot of executive agreements, particularly ASEAN agreements, which did not undergo ratification by the president. But still, they are considered to be effective for the Philippines. So, but if you read EO 459, it says, there has to be presidential ratification. But in the case of ASEAN agreements, even that is not there.
Thank you, Professor Raj. Professor Gatmaytan?
No.
I lost my camera. I lost my video again.
Just one small point, Paula, in addition to what Professors Rommel and Raj mentioned. And from the practical side, I think what would also help the court is the pleading of these issues when they arise in cases before the court. And so actually, this is an invitation to the international scholars here and to the public to invite the international law experts in the pleading of these issues, so they may be clarified as to the concept. And I often think about equality executive agreements as the Philippines taking the equality of states into overdrive and comparing itself to the US and its use of executive agreements. And that's where international scholars like the panelists would help in introducing what could temper that overdrive on the part of the executive and its alliance with the court in that regard.
Thank you. Yes, Dean?
Yes, Paula. Just to chime in a bit, I think the issue is a species of a larger problem of how do we use international law within the system, because we know it's a valid source of norms, obligations, but we haven't really, or our systems, our political institutions, the Constitution is the least we can really depend on this, has not delineated that. No? The most recent, perhaps, example also is the Pangalangan case, no, on the withdrawal from the ICC. So, and we find courts, we find the Supreme Court declaring customary law on its own without really any basis in other international tribunals. So I think that's the bigger problem, and we perhaps this community, especially the Philippine Society of International Law, could contribute or suggest that framework, or at least that infrastructure on how that can be solved. Because right now it's a free for all. That's that's what I'm seeing. And the problem is, while I'm not totally averse to judicial legislation, sometimes it's needed, but then eventually international law is an unwitting collaborator in that enterprise of creating norms or coming up with decisions that could be sound, but when it's reasoned in an international law sense, it becomes, I would say, weak or even vulnerable. So I suppose my call here, or the reason I spoke, is we have identified these issues, and I think we along with other faculties of law, other colleagues interested in international law, can propose something more concrete along these lines. Since it's a big gap, it's a big gap in domestic as well as our treatment of international law. Thank you, Judge Raul. Again, congratulations, and thank you to all.
Thank you. And thank you.
Thank you, Professor Mike and Dean Vistan. Thank you to our audience as well for sending in their questions and participating in today's Q&A. We welcome once again Professor Chu to give us closing remarks.
Thank you, Attorney Paula. I will be very quick as we have extended and you've taken so much of your time already. And I'll begin again by thanking Judge Raul Pangalangan for his work, without which we would not be here today engaged in this discussion. And we want to thank as well the UP College of Law and the Philippine Society of International Law, represented by Dean Carlo Vistan and Professor Elizabeth Aguiling Pangalangan, respectively, for making this possible as well. And we remain in the UP Law Center Institute of International Legal Studies to be at the forefront of these discussions, bringing these international legal issues and concerns home so that we can discuss about it and ruminate in the Philippines, and we can craft solutions moving forward. Thank you very much, everyone. Thank you, Attorney Paula, for moderating this afternoon's event.
Thank you, Professor Mike. We now conclude this colloquium on an important work of scholarship by our very own Judge Raul C. Pangalangan. Congratulations, Judge, and thank you for this massive contribution. The University of the Philippines, ILS, and Philippine Society of International Law express our sincere thanks to our esteemed panelists and to our distinguished author. Your efforts are key to understanding international law through the Philippine experience. Thank you, everyone, for joining us today, and good afternoon.
Attorney Paula, can we have one more group picture, please?